We'll just wait, yeah. Please come, please come. Please come. Aditya? Yeah, I'm just waiting for the faculty members to come. Please, let me have a seat. Okay. So, very good afternoon to everyone, and I would request everyone to kindly put their cell phones on silent mode and not on also on vibration mode. If it's otherwise, you can switch it off. It gives me great pleasure to welcome Dr. Lalit Bhasin, President of the Society of Indian Law Firms, to the BMU campus. He has been a great supporter. Yes, a big hand for him. Dr. Bhasin has been a great supporter of our law school. He is a member of our advisory council, and the comments that we have got through that advisory council has really shaped what the law school is today. I am really excited to announce that this is the inaugural session of the BMU SILF lecture series, and no better than the President of the Society of Indian Law Firms himself to inaugurate this lecture series here today at the BMU campus. It is a daunting task to introduce Dr. Lalit Bhasin, and so I cannot complete everything that I have in front of me, but Dr. Bhasin has been in the practice of law for over 60 years, and he is one of the eminent legal minds of India. He is the managing partner of the famous Bhasin and Company that all of you know. He is president of the Society of Indian Law Firms, but he is also national president of the Indo-American Chamber of Commerce. He was the immediate past president of the Bar Association of India, the chairman of the Chartered Institute of Arbitrators, India, senior advisor, South Asia, Oceania, and India Committee of the American Bar Association. He is chairman of the CII National Committee on Legal Services. He is former chairman of the Delhi Bar Council, former chairman of the Film Certification Appellate Tribunal, member of the International Court of Arbitration, Paris, and it can go on. So we really have a legal luminary here with us today, and we look forward to his lecture. But I must also mention that Dr. Bhasin was awarded the Doctor of Laws, which is LLD honoris causa by Jaipur University in 2013. He was awarded the Plaque of Honor by the Prime Minister of India in 2002 for outstanding contribution to the rule of law. In December 2022, he was conferred the Lifetime Achievement Award at the House of Lords in London by the UK-India Legal Partnerships. The topic that Dr. Bhasin has chosen, which is about notorious law delays in India, could not have been a better choice. The reason is that this is a kind of issue which we have been hearing about, not just, let's say, from the start of our nascent law careers, but one of the first committees was set up in 1924 by the Calcutta High Court to look into the question of delays in the Indian legal system. And there have been countless other committees which have been set up, 1949, Law Commission 69, 1978, and almost every other Law Commission report has thought about this problem of delays in India today, which has become a real pressing question of access to justice. People blame it on several things: infrastructure, procedural laws, the legal culture of the bar and the bench, but still we don't have a grip on what to do about this and perennial problem of the Indian legal system. So without much ado, I'd hand it over to you, Dr. Bhasin, to speak about the notorious delays in the Indian legal system. Please.
Thank you very much for your very gracious introduction. The topic is on notorious, but I can assure you I'm not notorious in that manner. And I have selected this topic because I feel very closely, you see, to the fact that whether Indian citizens are getting justice from the courts of India. I bring to you greetings from the Society of Indian Law Firms, from the Bar Association of India, from the Chartered Institute of Arbitrators, and various institutions which I happen to represent. I visit at least 2 law schools every month, spread all over the country. So it is not just the NCR territory, it is all over. Why I do so is not for the benefit of the students. It is actually for my own benefit. Because I consider these law schools as temples of learning. And for a legal professional, learning never comes to an end. It is a continuous process. A worker goes to a labor court, and then from the labor court, if the decision is against the employer, he'll go to the high court to challenge that and all that. That is not. Straight away there should be a provision that he can go to a court and get, some verdict or the other. So that is, and then it is a ironical thing that government is the largest litigant. In this country, government is the largest litigant, and this huge pendency is directly attributable to the government because they don't want to settle the disputes. I was advising a public sector undertaking, and there was a dispute about construction of a building, a dispute with the contractor. So I looked into the papers and I told them, I said, this contractor's claim is justified. Why don't you settle the matter? So that official of the public sector undertaking told me, sir, if we settle the matter, tomorrow there will be a CBI inquiry. Why did you settle the matter? There must have been something paid to you that you settled this matter. Rather, it's better that he goes to the court and gets a verdict and then we will pay him. So this is the sort of a thing which the frame of mind of the government and the public sector undertaking which are owned by the government. There was a move when Chief Justice Ahmadi was there in the Supreme Court. He had formed a committee of secretaries to look into inter-ministerial, inter-public sector undertaking disputes. But that also did not take off. It was functional for some time. After that, nothing happened. With the result that the government is on either this side or that side. In about 60 to 65% cases being the largest litigant. Therefore, if in one stroke you can reduce this pendency, if the government was to take a view that we will settle the matters, that we will not go in litigation after the first verdict comes against us. It becomes a matter of ego, because government is after all represented by individuals who are holding positions. So it becomes a matter of ego for that individual. Oh, I've lost the case, I will see him in the higher court. So this is the sort of attitude, which these government people have. Therefore, at one stroke, and we have been telling the government, I've been telling, the law ministers who have been coming and going, that please look into this. This 5 crore pendency can be straightaway drastically reduced if you try to resolve your litigations. And for future, don't go for litigation. Yes, you have to go if it is foisted on you, if someone challenges your action, but then accept the verdict. Don't just go on right up to the Supreme Court and all that and ask for the reviews and all that. Now, the question comes that within the framework, what can we do? We have this court system, we have the tribunals, so what can we do? The topic also says, and possible remedies. There is a lady faculty member, I think you are ADR? ADR, yeah. ADR means the alternate dispute resolution. So that was conceived as a possible solution to these mounting arrears in the caseload of the courts. Now, what is the alternate dispute resolution system? It is essentially arbitration. Earlier there was 1940 Act that was repealed, then the 96 Act came, it has gone so many amendments and all that, so we have that Act. So has arbitration been able to resolve any disputes in a reasonable manner? My view is that arbitration has failed to take off in India. People are looking for an alternate to this alternate dispute mechanism which was conceived as arbitration. Why it has become so? Because of mainly two factors. I'm glad there are no judges here. Mainly two factors. What are those two factors? Judges and judges. So someone say, how do you say judges and judges? So I say the first is judges when they intervene in the arbitral proceedings. That results in inordinate delay in the disposal of the arbitration matters. The intervention by the courts in the arbitration disputes, even today, for appointment of arbitrators, for getting an interim relief also, Section 8, Section 9, Section 11, then you challenge the award, Section 34, then Section 37. It's an elaborate procedure. Arbitration was meant to be a very expeditious way of disposal, a least expensive way of getting the matter disposed of. But the experience shows, and what is the second, judges? That arbitration is monopolized by retired judges. You look into any good arbitration dispute where corporates are involved, they always go to retired judges. Some even say, okay, we'll have former Chief Justices of India, former Supreme Court judges, High Court judges. It is all monopolized by the retired judges. And one Chief Justice, Chief Justice Kania, he told me, very honest judge. When he was from Bombay, he became Chief Justice of India. After retirement, he was accepting arbitration. So I have an office in Bombay, and he also had one chamber then in same. So we were going in an elevator. He said, Lalit, I have never seen so much of money in my life as I am making now. You see, and he said very honestly. So he must be making money the right way. But this is what has happened, that this is now monopolized by retired judges. And that also results in heavy increase in the cost. And I've seen these arbitrators. And I again say that with great certainty, that these arbitrators convert one day's sittings into two sittings. One is, okay, pre-lunch, that is one sitting. Then you provide us lunch, we'll have lunch. After lunch is the second sitting. Then two sets of fee are paid to arbitrators, possibly to lawyers also. You see, I can't leave out the lawyers also. They also must be getting two sets of fee. But look at the cost to the litigant. The cost to the litigant is enormous, much more than what he would spend in litigation. And then the dates are given because their diaries are full. Dates are given after 3 months, 4 months, procedural hearings, then the evidence is taken and all that. Therefore, arbitration also has failed, and that is also due to the fact that, just look at the irony of the whole thing, that the two corporates, two business houses in India, supposing they have a dispute, they would rather go to Singapore International Arbitration Center to get their dispute resolved and referred to, rather than go for arbitration in India, because they are good institutions of arbitration which inspire confidence with the parties that yes, we will get justice. There the institutions appoint the arbitrators, not the parties. We don't have institutions like SIAC, that is Singapore International Arbitration Center. We don't have institutions like the Dubai International Finance Center or the London Court of International Arbitration or American Arbitration Association. We don't have institutions here. Late one law minister, he's no more. He set up, you see, one ICADR, Indian Council of Alternate Dispute Resolution. A huge building was made, but in the building there was no activity. The building was really a piece of art, but intellectually it was a big, big zero. Nothing happened in that. That is how, you see, arbitration has developed in this country. One can call it development at all. It is a negative development, not a positive development. And it has failed to take off unless now the government and the business houses, the chambers of commerce, they take a lead in setting up good institutions of arbitrators, where the arbitrators are appointed depending upon the nature of the case, not that appoint judges. Now, supposing it's a construction dispute, you should have some eminent architect, some construction expert, some engineer who should be arbitrators. Why judges and lawyers should be there as arbitrators? Therefore, why I am heavily relying upon this criticism of arbitration is that it has failed to be an alternate dispute resolution mechanism at all. So where do we go? We go to our old ancient system of consensual form of justice, that is mediation. Mediation is the only answer. Mediation, you need trained mediators who should inspire confidence, who should know the law, who should know the facts, who should go through that. Mediation, that is samjhauta, settlement of disputes. This is what Justice Krishna here said. Yeah, way back in 1977. And Justice Krishna Iyer, one of the greatest judges that you see India has produced, he said in a case, some Agarwal Engineering versus Hungarian company, he says, a legal adjudication may be flawless but heartless. Just see the language. A legal adjudication may be flawless but heartless, but a negotiated settlement will be satisfying even if it departs from strict law. This is coming from one of the greatest judges, you see, way back in 1977. This is what he said. And I'm virtually a contemporary of his. We were very good friends. Even after his retirement, I was in touch with him, constant touch with him. And I got one slogan coined, which he approved, that a bad settlement is better than successful litigation. That a bad settlement is better than successful litigation. Now, how do we bring this change in the mindset of the people? To go back to our days of Manu Smriti and consensual form and settlement of disputes, that is your responsibility, the responsibility of this generation of students to bring about a change, you see, in the mindset of the people. Only 3-4 days ago, I was giving a lecture organized by Lloyd's Law School. And I told them, I say, you should introduce a subject on developing negotiating skills. Negotiating skills among the students, which would help the students, you see, to look into various aspects. That firstly, how do we settle this matter? Now, some of the students may become a general counsel in big corporate bodies. They may become lawyers, you see, they may become in other spheres. First, they would think, okay, there is a dispute, how do we resolve it? Let us sit together, let's have a dialogue. It will definitely result in something. Now, that is the responsibility of this coming generation of lawyers, of professionals, that first don't just look into, okay, dispute, he's right, he's wrong. No. Look into the facts of the case. Try to see if there is some meeting ground before you go to the court or before you go for arbitration, before you go there. Therefore, my message to this present generation, because our generation has failed to achieve that. Our generation has given you this negative, huge backload of 5 crore cases. Yes, we are also to blame. We can't just blame the government or the courts or anyone. We are also to blame. We also keep on taking adjournments on one plea or the other. Okay, I'm not well today, someone is not well, adjourn the matter. We have totally failed. This has resulted in this. Now the duty is cast on you and the law schools. You see, to have this mindset brought into being now, that try to settle the differences which exist in the parties. One of the parties you represent, one of the parties will be represented by one of your other colleagues in the profession. Therefore, try to resolve that. So friends, we are in the age of artificial intelligence. As the name itself signifies, it is artificial intelligence, because real intelligence is here. This is what has created artificial intelligence. Therefore, there can never be any substitute for human brain. And what I tell the law students whenever I go, that as there is no substitute for the human brain, there is no substitute for a law teacher also. You may use technology. You may think, I don't need to attend the class. I can look into the Google or whatever the research tool is there. I can find out much more than what this law teacher can tell me. But no, you are underestimating the significance and the role of a law teacher, who not only molds, you see, your thinking, your life, your brain, and how you should deal with situations which no computer can tell you. how do you put all that which is being taught to you into practice? That again, no computer, no technology will tell you. That the law teachers will tell you. Therefore, keep that in mind, that there can never be a good substitute for a law teacher. And similarly, there can be no substitute for a good law school also. And I compliment the dean and the faculty. They have put up an excellent center, you see, of legal learning here. And you, the students, are lucky and privileged to be a part of this. Next year, the first batch will move out, and I'm sure that they will contribute very, very significantly, you see, to the development of justice delivery system in this country, not based on just legalities and technicalities and law, but emphasis will be on justice. So thank you for sharing your time with me, and I'll be happy to interact with you and to respond to any queries or questions that you may have. Thank you.
So thank you very much for a very thought-provoking lecture, Dr. Bhasin. And it's also in one sense this entire philosophy of trying to find a meeting ground rather than what is right and what is wrong that ought to be debated. We have some time for question and answers now, and I will ask the students and also the faculty members, of course, especially the students, to feel free to ask questions to Dr. Bhasin. Maybe we'll go one at a time in the beginning. Keep your questions sharp and short so that we others also have time. I can already see a hand up, so many others.
My question is that as lawyers or these law students, we believe in formalization of laws. And with mediation being an alternate mechanism of, alternate expedient mechanism of dispute resolution or resolving legal issues, would that also not pose us some problems in the sense if mediation is to start with to pick up, then would that also not require a bit more backing of law, maybe a bit more formalization, and does that not have similar implications to that what you mentioned at the beginning, that you already have too many laws?
Yeah, it's a good question. Please sit down. You see, firstly, you yourself have to act as a mediator with your client. You look into the facts of the case and honestly advise the client whether he's got a good case or a bad case. And if you feel that the other side has also a plausible case, then you should try to convince your client, why don't you talk to me and try to settle the matter. If that stage is over, you two lawyers can talk to each other. And look here, what is the point of dragging this matter, you see, for years together, rather than there should be some give and take. In every settlement, there has to be a give and take. Parties cannot adopt rigid positions. You as lawyers and your client would listen to you with great respect if you were to tell him, look here, I feel after fighting this case for so many years, you may not get this relief. Therefore, it is better for you try to settle the matter with the other. Therefore, forget about the technicalities of law, but apply yourself firstly as a mediator with the client as to what you think about the matter.
Professor, my question is that mediation might be a helpful means of resolution in civil cases, but in criminal cases it might be disastrous. Like for example, you gave. So if a person gets to know that paying up the family for 6 months or 1 year or 2 years, he may get rid of so easily. So that might set a very bad precedent, and mediation then in criminal cases would become, I think, a disastrous impact. So
you are absolutely right. But in some of the other jurisdictions, particularly in the United States, there is always like a pre-trial stage where even serious offences are considered by the state's Attorney General. The matters are taken up to them. Then there is like a compromise arrived at with the aid of both the parties. That very well he is committed an offence, instead of 7 years in the jail, okay, give him 2 years. Or he should pay so much of fine. So this, even in criminal matters, pre-trial, it is called mediation. You see, that takes place. And in India also it has been suggested, Justice Maliman's committee report, it must be in the library. It's a very good report. They have suggested, even in criminal matters, pre-trial resolution of the matter.
There's a question there.
Good afternoon, sir. So, sir, my question is that as you basically talked about, you started with justice and then we came to the part of settlement. So, is it necessary that while having settlement, it will, lead us to justice? Because as you said that even arbitration has become a point of, monetizing. Like people are thinking, judges are going towards monetizing, seeing their own profit. So, like settlements can also become something like this because it can become a tool also to to basically back off your own liabilities, the original liabilities. Because if we even go for like settlements between firms, so most of the time there are big firms and small firms. So it can happen that the big firms can easily dominate the small firms and they can just go by just a settlement and basically save themselves from the original liability.
You see, what does the expression settlement mean? Settlement is a voluntary act being decided upon by a particular party. It is, a Hindi word is better, samjhauta. Parties come together. There is some give and take. You can't have, so there is no question of monetizing a settlement. Parties enter into settlement willingly, not due to any coercive method being applied. If the party feels, you said big client and a big firm and a small firm. Now, small firm obviously cannot afford to pay such legal expenses as the big firm would be. Therefore, the small firm, as a business policy, as a prudent business policy, will say it's better to settle it. I can't fight with this big firm, so I will agree for a settlement. So that is a voluntary settlement being entered into by two bodies. And the big firm is very well willing to settle. Why should I not settle? Therefore, that mindset has to be created. There is no question of people trying to make money out of settlement. We are not talking of those CBI raids, the people feel that allegations will be made that while you have settled this matter, something must have been paid to another table. No. And it is not a settlement, it is a fraud. That is a fraud.
Sir, you said that tribunalization of courts in India is just not helping. But don't you think that when we had tribunals, before we had tribunals, the number of cases are comparatively less right now compared to what they were earlier? And also, if you're saying that tribunalization in India is not helping, wouldn't it be better if we focus on making such tribunals more effective rather than just saying or coming to the conclusion that they're just not helping in India at all?
See, what used to happen when there were no tribunals? All the matters were going to courts. All the matters are going to courts. Now, if you have a look, I have a practical experience. I visit, you see, the National Consumer Commission, National Consumer Redressal Commission, NCDRC. I was appalled to see that within last 5-6 years, the passages leading to courtrooms are now flooded with files and files and files. With the result, this commission is not able to dispose of the matters. matters are just being adjourned. They have now about 12 members there. But nothing is coming out of that. So number is increasing. You go to the labor tribunals, where the workers' rights are involved. Claims are made by the employees. Cases are pending, piling up. So where is the disposal? Why not strengthen the infrastructure of the court system? Why we don't have one uniform court system prevalent, you see, for all types of cases as earlier used to happen? Ever since, you see, this tribunal thing has started, the workload of the tribunal has not decreased, it has increased significantly. Go to any consumer fora, any of these tribunals, NCLT was supposed to be something which would immediately resolve a dispute. Now insolvency disputes are also going to NCLT. And look at the fate of the cases there. They are piling up like anything. My own experience is, for last 1 year, one case has been coming up as item number 220 something. It never reaches. At the end of the day, after waiting for that, we are told, you see, okay, date is given, next day. This is what has resulted, you see, because of tribunalization. I would have agreed with you if tribunal had helped in reducing the number of cases. On the contrary, the number is going up and up. Yeah, sure.
Tasneem, you had a hand? Yes. And then Harshit.
Sir, notice that across India, across law schools, lesser number of students and graduates are taking up independent practice, and rather they're moving more towards corporate litigation or other forms of other spheres of law. So, do you think that would also cause a problem when we're looking at a standardized system? If you want to achieve a standardized court system or mediation system, that would become a problem in that scenario when you have lesser workforce having an independent litigation practice?
See, law practice is one thing which depends on one's aptitude. I have daughters. 2 daughters wanted to be lawyers. Fine. One daughter thought, you see, that she would like to become a jewelry designer. I said, okay, you become a jewelry designer. We sent her to California, Gemology Institute. She studied there. So she became an expert. Now these 2 daughters who are lawyers, they practice law, and they said, no, I think we'll do some other thing. So they left that. It's a question of aptitude. Aptitude, when we talk of, as I was telling you, what is your first name? Harshit. Yeah. He escorted me from Delhi, you see, to this law school. As I was telling him, it's a matter of aptitude. He asked me the same question. Firstly, you have to decide you want to be a litigation lawyer or a corporate lawyer. So many ladies, I'm talking specifically, they prefer to be corporate lawyers, go to the law firms and all that, for various reasons. Because ladies, you know, they have to be wives, they have to be mothers, they have to look after their parents, their in-laws. So they have so many other responsibilities coexisting with their responsibility as a professional. I marvel, you see, how they accomplish all that, because we men, we only go to the court or attend to the clients and all that and come home and have our food. But then again, a question of aptitude comes in. Ladies generally would like to go to corporate. Among the male students, they may like to go for criminal litigation. They read in the newspapers, you see so many things, scams happening, this happening. So someone denied bail, someone granted bail, someone raped, and this is what has happened. So they want to go, you see, litigation, practice criminal litigation. Some people want to go to civil litigation. Civil litigation has so many facets also. Like some people want to go to the High Court to do only the writ jurisdiction. Article 226, 227 do all together. And then some are in the trial civil matters. So it all depends on the aptitude. So I don't know what your question implies. One can never fix the either according to gender or according to what it will be if more lawyers go into litigation or less lawyers go into corporation. You can't imagine these things. It will still depend upon the aptitude, because you can't tell a lawyer, supposing you want to go to a law firm, I cannot tell you, no, go to a litigation lawyer. So regardless of what sort of imbalance it may create, it will always be a question of aptitude. Because if you are put in a place where you are not comfortable, the type of work that you do, then it will drive a wastage of it.
One thing that Tasneem was also asking was that if there are lesser number of law students going to the bar for litigation and more going into corporate practice, then will it affect your vision, which is to say that there should be more mediation or there should be uniformity in courts?
No, mediation covers each and every aspect of law practice. Mediation does not mean only commercial disputes and all that. Mediation is there in family matters also, family courts, everywhere mediation is there. As I suggested, you answer to him even in criminal things, you see. For small matters, the courts are now encouraging parties to settle the matter. Even if it is an offense, say for instance, labor prosecution under the Provident Fund Act or other acts. It is the person, they will say, okay, why don't you plead guilty? We'll put a fine of 5 rupees, 10 rupees, 100 rupees. That is also like mediation.
Maybe we'll take 3 more questions. There are several. So there is one here, Harshit. Oh, you also want
I can ask my question.
Maybe yours can be the
Last
one. Faculty member, let the students go.
Yeah.
And no second questions. Let's first go with the ones who have got it. So Harshit, and there are 2 here. There's also Humam. But if you have shorter questions, I think it would be easy. So quickly.
So one of the most important points that you said, that government being the largest litigant. So we are talking about the mindset of the government, that they go on appeal and appeal. There are various big corporates, insurance companies, etc., who go on appeal and appeal. So how do we change the mindset of the people itself? Do we make mediation mandatory? So
mediation, a new bill has been introduced in the parliament, the mediation bill. That will try to make things easier. But we don't know when it will see the light of the day, how long it will take. The parliament is busy in so many other things, more important things than mediation of disputes. Mediation mindset is inherent in people. We have forgotten that. And that is why again and again I was reminding you about our ancient culture, where we all believed in consensual form of dispute resolution. Dispute is there, but then there is the modality of consensual form, not adversarial form. This mindset, you people have to bring a change. You are the lawyers, you see, of tomorrow. This mindset you can bring by advising your client properly. Not become a lawyer, tarikh pe tarikh, every tarikh involves more fee. Ye nahi.
Maybe take 2 questions here.
So you mentioned like you should adopt pre-trial mediations in criminal cases. So don't you think adopting this method will be aiding to the rich people? They'll pay and they'll escape from the liabilities, and the crime rates might also increase by adopting such methods in criminal cases.
This question is saying that if there is pre-trial mediation in criminal cases, then will it favor the rich and powerful, because then they'll be able to pay and get off their liability?
Yes.
It will not, you see, because after all you have to follow certain model. As we have seen in the United States, it's a very successful way of resolving, you see, so many disputes of criminal nature. And the charges are also very serious. Even in cases of murders, culpable homicide amounting to murder, homicide not amounting to murder, something, you see, they have, okay, life term for this lesser term. So the prosecutor and the parties, the lawyer for the accused person, they decide among themselves. So there is no question of rich or poor. It is not just a monetary settlement.
Yeah, two more questions. So first, Samiksha, then.
So I agree when you say that we must have these negotiatory skills and we must negotiate as lawyers. But what if our client who's filing a case, he wants to go for the traditional approach and he wants to file a case. In that case, this approach, how can we as lawyers, what can we do in that case? Because since this approach is being this is the traditional approach that only if you will file a case, then only you will get justice.
No, it is your duty to conduct the case of your client. If he agrees with you for settlement, well and good. If he does not, then under the existing rules of etiquette and rules of profession, a lawyer cannot refuse any brief. So you have to accept the brief and appear for the client if he says, no, I don't want a settlement. But there can be so many clients who say, no, I would rather fight it out, I do not accept a settlement. Then it is your duty, you see, to fight for your client. Eventually the court will decide whether you are right or not.
Last question from us. Okay, student.
First of all, thank you for the lecture. So my question is that going in the mindset first has to come from the Supreme Court of India. Supreme Court today has overburdened itself with all sorts of matters. If it's stopped accepting appeals on every other matter, then we will not have
I can't hear you properly.
Yeah. Can you be a bit louder?
Or come this side.
So don't you think that change in the mindset first of all have to come from the Supreme Court of India? Because Supreme Court has now overburdened itself with all sorts of matters because it is accepting appeals on all sorts of matters. And if you look at other jurisdictions, their Supreme Courts are just the constitutional courts. So they take only the constitutional matters. I was listening the other day a lecture that Justice Narayan gave, and he called that it's very sad that Supreme Court has become a national court of appeal. Not a constitutional court, but a national court of appeal. Don't you think the problem arises with this?
Oh, you see, it's a very relevant question, but this was examined by our constitution makers at the time of framing the constitution. What should be the scope and ambit of Article 136 of the Constitution of India? Should the Supreme Court be only a constitutional court, or unlike other jurisdictions, it should be a court where the citizens can also go and approach the court under Article 136. It was not just a constitutional matter. It was not created as only a constitutional court. It was created as a court of appeal and a court of final resort for the citizens. That was the distinction between a constitutional court and a court of final resort, that is the Supreme Court. And Dr. Ambedkar very clearly said that unlike other constitutions, I don't want this, you see, to just be a constitutional court where only 5 or 6 cases in a year, like the United States Supreme Court, they come there and you see there also time limit is prescribed. Within 30 minutes you give your presentation, within 30 minutes you give your presentation, we reserve the judgment. So our constitution is more people oriented that way. That people should have the right to go up to the Supreme Court, even in ordinary matters, if some question of law is involved. or if grave injustice is given to them. That is why 136 has to be read with 141 and 142, doing complete justice. 142 is doing complete justice, where the Supreme Court can ignore any law and pass an order which may not be supportable in law. So 142 is that. Read with that, another remedy was given, Article 32. That citizens could approach by way of a writ petition to see the Supreme Court of India for any breach of fundamental rights. So our Supreme Court system is entirely different from the other jurisdictions.
So we are running short of time now, so if you wouldn't mind, maybe we'll stop with Sonika's question. Your question.
So I still have some thoughts on your thoughts, so that we can discuss after the lecture also. Probably we could take one more question.
One last question. You have your hand up, so one brief question.
So, thank you, sir, for a nice lecture highlighting the pathology of Indian legal system, modern Indian legal system. So, it reminded me of a paper by Professor Bakshi from Takrar, which he published in 1980s, and also the scholarship of comparative law in India from Mark Gallenter to Bernard Cohn. So, my question is that. My question is a bit digressing from the topic you had in hand. So I want to ask that when you were highlighting that the Indian legal system at the point when British came was not exposed to the adversarial sort of system, was it this knowledge with the Constituent Assembly when they were framing a constitution which supported the adversarial form of litigation?
When the Constitution was being framed or drafted, but I was not consulted at that point. But certainly they had in mind that, but by that time we were, you see, completely drenched with the French Revolution, the equality, fraternity, liberty principles, with in a way the British taught us, they taught us all this, and our leadership was groomed in that. Whether it was even our father of the nation, Mahatma Gandhi, he was a lawyer. He knew all this entire system. Our first president, Dr. Rajendra Prasad, he was a very eminent lawyer. Pandit Nehru was a lawyer, Sardar Patel was a lawyer, Dr. Ambedkar was a lawyer. They all very well knew this, and they knew that they have to adopt this system with certain modifications. Therefore, no one applied their mind to having, you see, that original consensual form of system, keeping in view the huge population that we have and diverse cultures that we have, different communities that we have. So, no one applied their mind, strictly speaking, to that. That is why I said that we are now, we have this constitution, we have to work within the framework of the constitution. Therefore, keeping in view this topic which I have, the only way I find, the only remedy I find, the framework of constitution to have some jota, settlement of disputes, as Justice Krishna Iyer had said. A bad settlement is better than successful litigation.
Thank you so much, Dr. Bhasin, for engaging with us in this. I will first invite Professor Sonika Vajpayee to deliver a formal vote of thanks.
Thank you so much, sir. On behalf of the BML Munjal University, our students and the faculty, I would like to thank Dr. Lalit Bhasin for a delightfully engaging lecture. We are very grateful that you took out the time from your busy schedule to come to our campus and deliver this lecture. As Professor Barua mentioned, this lecture was the inaugural session of the BMU SILF lecture series, a collaboration between our university and the Society of Indian Law Firms, to encourage the discourse on emerging legal trends in legal practice. The School of Law at BML Munjal University has a strong emphasis on experiential learning, and it reflects in our pedagogy, assessments, and in collaborations like these. I'd like to thank the Society of Indian Law Firms and the member firms for being a part of this lecture series. Through this collaboration, you have demonstrated your commitment to bridge the gap between what students learn in a law school and the skill set expected out of them when they join the profession. Hopefully, together we can better prepare our students to transition from being law students to young professional. This vote of thanks would be incomplete without mentioning various teams across the university which have worked hard to make this event run so smoothly. This includes teams handling communications, IT and procurements. My special thanks to Mr. Indrajit Singh, Mr. Fahad Mohammad Khan, the members of our Moot Court Association and other student volunteers for their valuable contribution to this event. Lastly, my heartfelt thanks to each and every one of you present here, as well as those who have joined the session online. Your enthusiastic participation makes the event what it is. Now, I would like to request Professor Barua to present a memento to Dr. Bhasin as a token of our appreciation. And sir, I will also give you the book. This also needs to be given. This one.
This is our BMU memento. We'll take a photograph.
I will just.
I don't have a glamorous gift to give back as a return gift, but I do present to the law school. This is the coffee table book on the Society of Indian Law Firms. It has got the details of 120 topmost law firms of the country, published by the Society of Indian Law Firms. So this will be I think, a very valuable addition to your library.
It will. Thank you so much.
Along with that, again, a very valuable contribution to your library will be the 70 years of India's constitution that was in the year 2020, and it is celebrating and celebrating 70 years the constitutions of India, compiled and edited by Lalit Bhasin. It is, as President of the Bar Association of India, I had brought out this book.
Thank you so much. We are delighted. So we can then make a move. That was very good. Really delighted. The students also were excited asking questions. Yes.